What do we do when a client tells us he is guilty? This is probably the most common question any lawyer is ever asked, particularly followed up with, how could you defend somebody for X, Y, or Z? Now, there's a number of ways a client can tell you that he's guilty, or in a civil sense, wrong in the claim that's coming to court. And as you can imagine, there's lots of different rules about each scenario. So in order to understand what a barrister can do when a client has admitted he is guilty of the offence, it's important to look at the rules. The most fundamental of those rules are the core duties set out in the handbook, which is the book of rules created by the Bar Standards Board, which is the bar's regulator. The first and the most fundamental of these duties, core duty 1, is a duty to the court in the administration of justice. Simply put, this means you cannot mislead the court in any way. And it should be obvious as to why that is. That's because the court must have all of the correct facts before it, before making any finding of fact or law. And a finding of fact in a criminal trial in the Crown Court is made by a jury. But as the jury become part of the court in that sense, it is essential that they are not misled. The second of the core duties is to act in the best interests of the client. And there are lots of rules around this, but simply put, it means to put your client's case as best as you possibly can within the rules. An example of this that relates to guilt is that we must advise a client to plead guilty if they've told us they are guilty and there's no valid defence, because they will get a reduction in sentence depending on how early they plead guilty. That's why it's important to get advice as early as possible. Under core duty 4, we must remain independent at all times, and that is independent both of the instructing solicitor and of anybody else, and you are acting for the client, but you must maintain your independence. Core duty 5 says that we must not act in a way that is likely to diminish the trust and confidence placed in the profession. Clearly, this ties in with the duty to the court, because if we were acting in a way that misleads the court in that sense, then it is likely to diminish the trust and confidence in the profession. Core duty 6 is one that relates strongly to the elements of admitting guilt, because under core duty 6 we must maintain our client's confidentiality at all times. So in a hypothetical scenario, you are the barrister and you sit down in conference with a client for the first time. He's charged with an offence, and right off the bat he admits to you that he committed this offence and he just wants you to get him the best result possible. What do you do? Well, in this scenario, it's not as simple as the client's told you that he's done it and therefore he's guilty and therefore you advise him to plead guilty, because there may well be a valid defence. For example, if I tell you half of a story, it might make you feel that the client is guilty. If the part of the story that I tell you is that my client punched another man in the face and he told you that he did that, then he sounds guilty of punching the man in the face. But if the first half of that story, that it was at night, he was walking home, the other man was in a gang of 3 or 4 other men and they'd come to mug this man, they'd all got bats or sticks or something else and they were coming to attack my client, and in a desperate attempt of self-defense he punched one of them in the face and ran off, then he has very likely got a good defense of self-defense. This is why it is important to go right to the beginning, go through all of the facts and find out why these things happened. This is obviously a very simplistic and obvious scenario, but it's not always that obvious and it's not always that simplistic. So there are lots of questions that you would need to ask to establish whether there is a valid defense. Because by default, if there is a valid defense, then the client is not guilty and we would have to advise that they plead not guilty. If, having been through all of the facts and all of the scenario, and there really is no defense, if my client was the other man who was part of the gang of robbers coming along, then it's very unlikely that there's any valid defense there, and if he tells me that he did it at the start of a conference, then by all accounts he is guilty of that offence, and then you have more decisions to make as the barrister. In this second scenario, if you are representing one of the attackers and he admits to you freely that he was part of a robbery gang, he injured this other man, you've had a detailed line of questioning with this client and there really is no defence, but he still wants you to defend him, you then have a choice to make as to how you put the case to the court. And this is where those core duties and the application of those core duties come in. The fundamental duties and difficulties that you have in this scenario is that you have a duty not to mislead the court under any circumstances. You cannot lie to the court and you cannot lead the court to believe something is true if you know it to be untrue. On the other hand, you have a duty to act in the best interests of your client. So you don't just withdraw because they've told you that they are guilty of it. You still have to act in their best interests, even if that is to advise them to plead guilty. But the ultimate choice is theirs. If they still choose to plead not guilty, that is their plea and that is their choice. You can advise strongly that it's a bad idea if you know that they are guilty and it's very unlikely they'll be acquitted, but ultimately it is their choice. So you still have to act in their best interests and represent the case as best as you can within the rules. But in doing so, you cannot set up a positive case to tell the court that your client didn't do it if you know that your client did do it, because that would be misleading the court. You also cannot suggest that somebody else might have done it because you know it wasn't somebody else, you know it was your client. That would be misleading the court as well. You also cannot say that your client was somewhere else or suggest that he might have been somewhere else because you know that he was there, because he's told you that he was there, he's told you that he did it. So in this situation, you cannot mislead the court. You have to act in your client's best interests, but you can't do that by telling the court or leading the court to think that your client didn't do it. But also in Core Duty 6, you have a duty to maintain your client's confidentiality. This means you cannot tell the court what your client has told you if it's against his best interests under Core Duty 2 without his consent. So unless your client tells you to tell the court that this is what happened, which is unlikely, you cannot tell the court that either. So how is it that you go about representing your client's case as best as you can without misleading the court, representing his best interests, not breaching his confidentiality, and under Core Duty 5, not bringing the profession into disrepute by acting dishonestly? The answer is as follows. All you can do in this situation is to test the evidence of the prosecution against this defendant. Because after all, the prosecution bring the case, the prosecution must prove the case. It is not up to the defense to prove that he didn't do it. It's up to the prosecution to prove that he did. And there's a very important reason why this is so. That is because a fundamental underlying principle of the justice system is that the prosecution must prove the case against the defendant. If they cannot prove the case against the defendant, they would be relying on the defendant admitting his guilt, which in this scenario, he's not doing. So the only alternative to the prosecution proving the case would be anybody's best guess. We are not asking a jury to guess whether they think that this defendant committed this crime and had no defense. We are asking the jury, which is a safe test for a conviction, whether the jury are sure that this defendant committed this crime. The follow-up question is almost always, why can we, the barrister, not tell somebody that they've admitted to us that they did it? And the simple answer to this is no one would ever seek legal advice if they believed that you were going to leak their information back to the prosecution and land them in prison. Now, many of you might think that that's perfectly fine because if they did the crime, they should do the time, as the saying goes. However, as I said earlier in the video, the defendant may not know that they have a valid defense, and therefore they need to come for legal advice in order to determine whether it is a valid defense or not. Take the scenario of self-defense. The example I gave you earlier was very straightforward. If there was a gang of men attacking my client and he lashed out at one of them in self-defense, then it's quite clear to me that he's telling me that he acted in self-defense. Whether that's the truth or not is not for me to decide. But let's change that situation very slightly. Let's say there was a huge crowd of people. You've got 7 or 8 witnesses all saying very slightly different things. Some of them say your client started a fight. Some of them say the gang of men were attacking him out of nowhere. Your client says it was self-defense, but these men also say it was self-defense. Then it is not quite so straightforward. Your client may then come to you telling you that they are guilty because maybe they did punch the other person in the face, but you would have to examine that scenario to determine whether or not there is a valid self-defense argument there. But if the rules of confidentiality were not in place, any of these clients would be scared to come for you for legal advice because they wouldn't know whether or not you're going to tell the prosecution everything you've told them. So confidentiality to your client is key. But this confidentiality works in tandem with the other core duties to prevent a barrister from misleading the court. The other way a client could have let somebody know about his extent in the crime itself is through a confession. A confession is defined under Section 82 of the Police and Criminal Evidence Act 1984 as a statement which is wholly or partly adverse to the person making it, whether it is made to a person in authority or not, and whether it's made in words or otherwise. In other words, it could have been written down, or it could be a picture, or anything else that could involve some level of guilt or involvement. A guilty plea is obviously the most formal form of confession, but in any other scenario there are several things to consider. And it's possible for such a confession to be excluded as evidence, and there are three main grounds for this. First of all, quite obviously, if it's obtained by oppression. So if somebody is being punished or tortured into giving a confession, then it will become inadmissible. Secondly, that the confession just isn't reliable in all the circumstances. So if the person is very severely drunk or high on drugs, and what they say is just not reliable. And also where admitting the confession would have an adverse effect on the fairness of the proceedings. Obviously, there are lots of rules around each of these elements, all carefully intertwined to make the proceedings as fair as possible. So ultimately, the takeaway from this is that if a client has admitted that they are guilty or were involved in the offence, that is not the end of the story, because there may well be a valid defence, and even if they are guilty and there isn't a valid defence, the prosecution must still prove the case against the defendant, because otherwise it just wouldn't be a fair trial, and we cannot proceed on the basis that anyone that says that they are guilty of something are automatically convicted. If you have particular questions that you would like answered by myself or any of my colleagues, why not head over to patreon.com/BlackBeltBarrister. There'll be a link in the description, and we'll be setting up a community questions forum where you can pose your questions and we will answer them. Obviously in an educational scenario, not to replace legal advice. But thanks for watching, and I'll see you next time.